Okay, and with that, welcome back to the Home Show here on News Talk 870 KRLA. I am Jessie, Lovelady, having a great time learning some stuff, and I'll tell you what, I have the best. This is very interesting. I'm interviewing attorney Forrest Wolfe. Want to give you his direct number so you don't forget it. I know a lot of people say, well, you only say the number one time. No, I'm not. I'm saying it over and over again. It's area code 909-391-3322. That's area code 909-391-3322. Want to let you know, too, that he will get back to you. Obviously, we're doing the show at 9 p.m. You're listening tonight, and then it'll rerun again. So we want to make sure that you get that. Now, you also have two offices, too, so I want to let people know you have two locations as well.
That's right, Jessie.
And we have a toll-free number that we can give them for that one. That one is in Palm Springs. Woohoo! Hot out there, but I like it. 866-535-5301. That's toll-free, 866-535-5301. So make sure we have two locations for you. Okay, listeners, now, this is really important. This is about our life. This is about our family. This is so important. I'm so interested in listening to what you have to say. And we just finished up with talking about putting your child's name on the property deed. Woo, that is something. I bet you somebody's out there just going, uh-oh. Now, what is the difference between an executor, trustee, guardian, or someone with a power of attorney? That one I want to know.
Yeah, that's a good question. Basically, a power of attorney allows you to operate on someone's behalf in financial matters. It can either be a power of attorney that takes effect immediately, a durable power of attorney that continues when you're incapacitated, or a springing power of attorney that doesn't take effect until the doctor certifies you're incapacitated. But really, it can do some of the things that a trust does for you, but unfortunately, a lot of people have the misconception that by giving someone power of attorney, they can take care of things while you're alive, and upon your death, they can distribute your property. But a power of attorney always ends upon death. So while you may have been able to handle things for someone while they're alive, as soon as they've passed away, again, power of attorney ends, and if you don't have a living trust, property is going to have to go through probate. Another problem is a lot of times people will, unfortunately, come to me too late. They'll say, Mom or Dad just went into a nursing home, or they're in the hospital, they're not able to communicate. I need a power of attorney over them. Well, of course, the only person who can give a power of attorney is your parent or whoever it is that's in the hospital, and by that time it's too late.
Wow,
so you want to make sure you get that done ahead of time. Now, in terms of executor and trustee, their jobs are about the same. They're basically going to handle the financial distribution of your estate. Guardian, on the other hand, usually if you've got minor children, you're going to want to name a guardian. That guardian is going to make all the personal decisions for your child. If you have a living trust, the financial decisions won't be in the hands of the guardian, will be in the hands of the trustee. But you'll want to name guardians for minor children so that person is going to determine where they live. It may be with the guardian, it may not, but the guardian is going to make that choice where they're going to live, where they're going to school, who they're going to associate with until they turn 18. So it's always a good idea to name a guardian. And that's usually done in a will, whether or not you have a trust. You name the guardian in your will for someone to take care of your kids for you.
That's, again, very interesting. Now, who can be the trustee of a trust?
Basically, with a trust, you have three parties. You've got the settlor, which not a pioneer.
Okay.
California, we use the term settlor. Sometimes referred to as a grantor or a trustor. But basically, the settlor is just the person that creates the trust. The trustee is the person who's going to manage the trust, invest the assets, and make sure they get distributed according to what the trust says. And the third party is, of course, the beneficiary. Ordinarily, with a living trust, the person that creates the trust, the settlor, is also going to be the trustee and the beneficiary during their lifetime. But, again, upon their death or upon their incapacity, they're going to have alternate successor trustees. So within the trust itself, whoever creates the trust is going to set up who they want to take their place if they're not around, the successor trustees. And basically that trustee can be anybody who's legally competent, who's over the age of 18, although most people, especially if they have grown children, A lot of times they're going to choose one or more of their children as trustees, but it can be anybody. It can be a friend. It can be someone they trust. It could even be their CPA. Occasionally it's an attorney, but it can be anybody. If you don't have someone in your family or someone in your social circle that you trust, there are corporate trustees. There's companies that all they do is manage trusts. Most major banks have a trust department that will also act as trustee. Most important thing is don't just name your one best trustee. Make sure you have alternates in there because when the time comes, that person that you've named may not be able to do it or may not be willing to do it at that point. So it's a good idea to have alternates in there. So if the first person can't or won't when the time comes, you've got other choices. If you run out of people, again, it's going to have to go into the court system. You're going to have a judge determine who would make the best trustee. Usually your fourth, fifth choice is still better than having someone who doesn't know your situation, your family, choosing the trustee for you.
That's a good idea. I mean, again, you're educating me. I want the listeners to know that if they would like to set up an appointment with you, give you a call on any of these things that we're talking about, and like I said, we all have a life, and we all, I mean, I've heard people say, I don't have anything to leave. I don't have anything. And I'm sure you can probably address that we all have something.
That's right.
And want to give you our attorney, Forrest Wolfe's direct number so you can reach them at area code 909-391-3322. That's area code 909-391-3322. And also, we have a toll-free number. Want you to know that he has 2 locations, one in Ontario, one in Palm Springs. And here's a toll-free number for you, 866-535-5301. That's toll-free, 866-535-5301. And also, they can email you as well, correct?
Sure.
And where can they email you at?
Forrest, Forrest, at TrustWolfe, TrustWolfe.com.
Okay. Do you still need a will if you have a living trust?
That's a good question. A lot of people, if they know something, they know the living trust, for most purposes, really takes the place of a will. But unfortunately, it is also like a contract in that it only covers property that is registered or titled in the name of the trust. So if you don't put all your property in the trust, if you forget to put one of your bank accounts or you forget to put one of your stocks or real property or your timeshare, whatever it might be, you have to have some method to basically determine the disposition of that property.
Sure.
So again, you will have a pour-over will. It's called a pour-over will, just like it sounds. Take a pitcher of water, you pour it over into the trust. So the trust will ultimately say who gets what, but you have to have that will. Otherwise, again, if there's anything outside the trust, it follows the intestacy statute. But you really need to have that pour-over will. For example, maybe you play the lottery and you finally get those winning numbers and you're so excited you have a heart attack before you get the money.
Oh.
It's not in your trust yet.
Yep.
So it's going to have to go through your will. And any portion of your estate that goes through the will, of course, like we've talked about, is going to have to usually go through probate. But you always want to have that pour-over will with the living trust just to make sure everything is covered.
Now, what advantages or protections does a living trust provide for younger beneficiaries?
That's a good question. I mean, one of the main advantages, besides avoiding probate, is the ability to basically say at what point your beneficiaries are going to receive your property. Obviously, after your death.
Right,
hopefully.
right.
But, and a lot of times it's not necessarily younger beneficiaries. I mean, it's pretty obvious that if you've got minors, someone under the age of 18, they're not going to be able to take care of their own money. But a lot of times you've got maturity issues that may not necessarily be age-related. You may have beneficiaries that really can't manage their finances, or maybe they've got long-standing creditor problems. So basically, in the trust, you can say when they're going to be entitled to the property. A lot of times they'll say maybe they get half the property at age 25 and half at 30, or a third at 25, a 30 and 35. Kind of a staggered distribution, so maybe if they weren't mature enough the first time they get something, they still can do something with inheritance, buy a house or something like that. Yeah, so you can put whatever restrictions you want on there. Ordinarily, you're going to make it so the trustee has the ability to use the money for the beneficiary's support and their education, whether it's college or they might want to become a lawyer. I don't know why, but they might. But basically, you can say when they're going to receive that. Some people even use it as an incentive. They don't want their kids just sitting around and waiting for them to pass away and take their property.
Oh, sure.
They'll say, at the earlier of graduation from college or age 30,
that's a good idea.
You'll be entitled to your property. Or each year of the trust, the trustee is going to pay you an amount equal to whatever your W-2 says, or if you're self-employed, whatever your Schedule C shows. So that way, it's kind of an encouragement to your beneficiaries to go out, better their lives, and then they'll get their inheritance sooner.
And I have to say to you that this is so important for people to pay attention to what you're saying, because again, maturity, age, whatever, can make a difference, and just want to stick to that. Now, we have a couple minutes, so I want to I have lots of questions I'd like to, I know I'm not going to be able to just finish this, but we are going to have you back. Are there any disadvantages or pitfalls in creating a living trust?
Well, there's none that are, no outright disadvantages. I mean, obviously, you're going to probably pay a little bit more to the attorney to create a living trust than to just do a will. Again, we haven't talked about it, but when you do a will, usually you're also going to want to do a power of attorney, living trust, and advanced health care directive so people can make health care decisions for you. But other than the additional cost for the living trust, really the pitfalls I see are, as we've talked about, if you don't fund the trust, which means you don't retitle your property into the trust. Ordinarily, a competent attorney is going to make sure that your real estate gets transferred into the trust. It's going to change the title from John and Jane Doe joint tenants to John and Jane Doe trustees of the trust. And just by filing that deed, that's how property gets in the trust.
Oh.
But if you don't re-register your bank accounts or any other assets, again, you've paid more for the trust, but part of your estate's still going to have to go through probate. So again, failure to fund the trust once it's set up is a potential pitfall. The other area you need to look at, and again we've touched on it a little bit, is naming trustees. Again, these need to be people, as the term says, that you trust. Because, again, if you go through probate, again, the judge has to approve most any transactions. But again, the trust is going to keep you out of the court system. So really, the trustees need to be people you trust, because, again, if they're going down to take money out of the bank doesn't have to question them if they're giving that money to the beneficiaries or if they're taking a trip to Las Vegas or whatever it might be. So you need to make sure that you pick trustees
that you can trust.
That you can trust. And if you don't completely trust someone but you really want them to act as trustee, you can have co-trustees, so it takes two people. You've got checks and balances.
Good idea.
Or you can choose a corporate trustee. Again, they're licensed, insured.
Or we can use our attorney.
Yeah, or you can use your attorney. But, yeah, those are really the main pitfalls that I see. Failure to fund the trust, failure to choose trustees. Again, a trustee doesn't need to know necessarily how to invest assets, but they need to know they don't know that and know to go see an investment advisor or see a CPA or see the attorney and get advice, which could all be paid for out of the trust. But they just need to know what they don't know so that they will act as your trustee in a competent manner.
Well, listen, we would like to thank you, our attorney, and of course, having you here is such a special, special day for us. And again, Attorney Wolfe, thanks once again. Want to give out the direct number for you, and that's toll free because we have two locations, 866-535-5301. And also, right here in Ontario, they can reach you at area code 909-391-3322. And just to mention to our listeners that, of course, you are a certified specialist, estate planner, trust and probate law is what you handle. And you're also part of the State Bar of California Board of Legal Specialization. I want to make sure I said that right. And they can email you at Forrest@TrustWolf. And I'm going to spell Forrest for them if they don't know. Forrest @TrustWolf. Wolfe, TRUSTWOLFE.com. And that's it. Thank you so much for joining us, and we look forward to seeing you again.
Thank you for having me, Jessie.
All right, bye-bye.